Part 1. The Reliance Shield. Protection from state grabbacks. Imagine you've spent 30 years planning your life around a specific state tax rule or a promised pension formula. You've made major life choices based on those promises. Can the government just waltz in and change the rules retroactively, costing you thousands? In a landmark decision, the Supreme Court just said a resounding no. In a massive shift of power, the court established a nationwide standard called fundamental reliance interests. In plain English, this means that if a government promise was so significant that it caused you to make major, irreversible life decisions, that promise is now protected by a powerful legal shield. The rule: if you made life-altering decisions, the state cannot pull the rug out from under you later. For example, maybe you moved from California to Florida specifically because Florida doesn't tax pensions. Or perhaps you delayed your retirement by 2 years because your employer promised a more generous cost of living adjustment for those who stayed. These are exactly the kinds of decisions this ruling protects. The example: let's say a state legislature facing a budget shortfall tries to impose a new 5% tax on your existing pension income, which was previously tax-free. Because of this new ruling, they now face a strict constitutional test they are very unlikely to pass. The shift. This is a monumental change. Previously, you had to prove the state was wrong, an uphill and expensive battle. Now the burden of proof is on the state. They must provide an overwhelmingly compelling justification for any financial harm they cause you by breaking their past promises. Part 2. The Military Goldmine. Soto vs. United States. If you are a military retiree with a combat-related disability, this next part is critical. It could be worth tens of thousands of dollars in tax-free back pay that the government previously denied you. For years, the government used an old law called the Barring Act to arbitrarily cap retroactive pay for combat-related special compensation, or CRSC, at only 6 years. This meant that even if you earned that pay a decade ago, you could only claim the last 6 years of it. The Supreme Court just struck that down in Soto vs. United States. The impact: an estimated 9,000 veterans are now eligible for years of additional retroactive combat-related special compensation. This isn't just a minor adjustment, it's a complete removal of the 6-year cap. Example: Marine Corporal Simon Soto was originally denied 2 years of pay from 2008 to 2010 because he filed his claim outside the old 6-year window. Let's say his CRSC was $500 a month. That's $12,000 in earned benefits the government kept from him. The court ruled he, and thousands like him, are entitled to every single penny of that back pay, no matter how long ago it was earned. If this information is helping you navigate these complex changes, take a moment to hit that subscribe button and turn on notifications. We track every major legal shift, so you don't lose the benefits you've earned over a lifetime of hard work. Part 3. 401k. Fee Crackdown. Cunningham v. Cornell. Are you being overcharged for your retirement plan? Hidden fees can silently drain tens or even hundreds of thousands of dollars from your nest egg. Most people are overpaying, but it used to be almost impossible to sue big corporations for excessive fees. That just changed. In Cunningham versus Cornell University, the court made it significantly easier for employees to sue fiduciaries who allow high-fee, prohibited transactions. A prohibited transaction is essentially a self-dealing arrangement where your plan pays an insider service provider, and the fees aren't reasonable or for necessary services. The new standard. This is a game changer. Plaintiffs no longer have to disprove a web of complex legal exemptions just to get their case heard by a judge. Now, you only need to show that a transaction occurred between the plan and an insider service provider. The burden then shifts to the fiduciary to prove the fees were fair and reasonable. The example: in the Cornell case, the university was paying providers like TIAA and Fidelity between $115 and $200 per participant for administrative services. The lawsuit alleged that a reasonable fee for a plan of that size was only around $35 per participant. That difference, multiplied by thousands of employees over many years, adds up to millions in lost retirement savings. The result? This lowers the bar for lawsuits, meaning more companies will be forced to scrutinize and lower their 401k fees or face massive jury awards, like the $39 million verdict recently handed down in a similar case in New York. Your HR department is now on notice. Part 4. The Warning. Stanley v. Sanford. Now, it wasn't all good news for retirees. In Stanley v. Sanford, the court ruled unanimously, 9-0, that disability protections under Title I of the Americans with Disabilities Act, the ADA, generally do not extend to retirees. The reality: Title I of the ADA protects current employees from discrimination. The court affirmed that once you are a former employee, you are no longer covered by that specific part of the law. This means if your former employer changes your retiree health benefits after you've already left the job, you likely cannot sue them for disability discrimination under the ADA. This ruling makes it more important than ever to get promises about your post-retirement benefits in writing. Review your plan documents, collective bargaining agreements, and any contracts before you retire. Those documents may offer protections under other laws like ERISA or state contract law. Part 5. Action Plan. How to protect your money. Knowledge is only powerful when you use it. To take advantage of these rulings, here is a simple 30-day action plan. Week 1. Document everything. Go to your state's Revenue Department website and screenshot or print the current tax laws for retirement income. Find and save your pension enrollment forms, benefit summaries, and recent 401k statements. This is your proof of reliance file. Week 2. Audit your records. If you're a veteran who was told your CRSC back pay was capped at 6 years, it's time to act. Gather your award letters and file for a correction with your branch's board. The Army is already reviewing 7,000 claims automatically, but other branches are moving slower, so you must be proactive. We strongly advise consulting a military attorney or a qualified veteran service officer. Week 3. Check your 401k. Benchmarks. Request your plan's 404A5 fee disclosure. Look at the administrative or record-keeping fees. If they seem high compared to the $35–50 per participant benchmark, you now have the legal leverage to demand a review from your employer's benefits committee. Week 4. Follow up. Submit your requests and set calendar reminders to follow up in 30 days. The Supreme Court has given you a shield, but you have to be the one to pick it up. Please note, this video is for educational purposes and is not legal or financial advice. Drop a comment below with your state or your branch, and let us know what retirement concern you want us to cover next. Thanks for watching.